The NSA has, in defense of this program, revised its figures recently and asserts that this program has prevented 54 terrorist plots. Is this program worth it?
First of all, we can't evaluate whether it actually has prevented plots without those plots being disclosed. But more importantly, we cannot evaluate the constitutionality of the program without the legal memos and the secret orders justifying it being disclosed. Here is my position. Let's assume the program works, and in that sense is worth it. It's still completely unnecessary to design it in a way that arguably violates the Constitution as well as the USA Patriot Act. And if it doesn't violate the USA Patriot Act, then the Patriot Act itself would violate the Constitution. I think that on the back of a napkin, Tim and I, with not too much time, could come up with legal restrictions on foreign intelligence surveillance that would both allow the government to have access to a lot of data that no human being could ever see unless there was a degree of individualized suspicion that someone actually was a suspected spy or terrorist, that no data of innocent people was seen, that the data was destroyed if it was not connected to a guilty person, and so forth. What does this regime look like? Much like the law did before 9/11. It's the regime that the Foreign Intelligence Surveillance Act in 1978 originally envisioned when it said that the government could seize without a warrant foreign intelligence information as long as it was a specified set of records and it was linked to a suspected spy or terrorist. What the Patriot Act did is eliminate the requirement that it could only be certain kinds of records and allow the government to hoover everything, but more importantly, to seize records merely by certifying that they were relevant to a terrorism investigation, not connected to a particular spy or terrorist. That was the troubling and arguably unconstitutional expansion that President Obama opposed when he supported the SAFE Act in Congress, and that Representative Sensenbrenner, the author of Section 215 of the Patriot Act, has now repudiated, and he has called for a resurrection on these requirements of particularity that a particular terrorist suspect be present. And then furthermore, there were further expansions in the 2006 amendments to the Foreign Intelligence Surveillance Act, which allowed data to be seized if it was tangentially relevant to an overseas communication, allowing the government to hoover up a lot of domestic calls and use algorithms that they claimed ensured that Americans were not being spied on. So this is not a complicated fix. I think it's very troubling that the opinions are secret, so I reject the idea that we have to say, is it worth it? I say, if it is worth it, let's have it, but let's make it consistent with constitutional limitations.